claim in this case is the deceased CHEAH had created two wills on 29 March 1989 and 16 April 1999. The plaintiff, Amy, who is the close best friend, was assigned as a trustee for the first will, and the plaintiff daughter was named as the estate sole beneficiary. On the other hand, the defendant, the biological brother of the deceased, whom she had been distant for 20 years, claimed that the deceased told her Amy had cheated on her by taking all the money from the joint fixed deposit account. She was really enraged and furious about the incident and wished to make a second will bequeathing all the estate to the defendant. Mr. Adamalai and his assistant, acting as a power of attorney, went to the deceased's house, assisting her to create the second will, which the deceased thumbprinted. Later, the plaintiff found out about the second will, which she claimed null and void. The plaintiff challenged the validity of the second will, claiming that the deceased was lacked testamentary competence since she was in a confused state of mind. She also claimed that the defendant had orchestrated the creation of second will was done under suspicious circumstances, including fraud and undue influence. There are two issues discussed in the present case. Firstly, whether the second will is valid since the deceased was lacked of testamentary competence at the time of making the will. Second, whether there is an existence of suspicious circumstances in the creation of second will on 16 April 1999.
So, the judgment in this case was delivered by Judge Balia Yusof, a judge from High Court Penang, and she stated that it is settled law that when the validity of a will is challenged, the burden of proving testamentary capacity and due execution of the same lies on the propounder of the will, as does the burden of dispelling any suspicious circumstances that may surround the making of the will. However, the onus of establishing any extraneous vitiating elements such as undue influence, fraud or forgery lies in those who challenge the will. For the reasons above as stated, the plaintiff's claim against the defendant is hereby dismissed, and the defendant's counterclaim against the plaintiffs, as enumerated in paragraph 19, A, B, C, and D of the statement of defense and counterclaim is hereby allowed.
Regarding where should resident die, the plaintiff had challenged the validity of the second will made by the deceased due to lack of testamentary capacity. Court had looked at the time of making the will to determine whether the deceased had sufficed the testamentary capacity. Based on CHEAH on wills, court referred to the period of deceased during the preparing her will and her conditions to understand and aware of her instructions and intentions upon the will that have been executed. Next, court had referred to the case Kau Cheng Bo, where elements of sound mind and understanding the context of a will make the will to be valid. Court also referred to the condition of the deceased not only during the time of the will was made, but also the deceased's mental condition during her sound mind state as required under this case. It was found that the day before she made the will, she had winced angrily with the plaintiff and expressed the intention to change her first will. Within the referred case and evidence presented, court found that the deceased had sufficed the testamentary capacity during the time the will was created. In other words, the will was made at the time she was in the state of conscious and aware of the condition and effect of the will made by her.
As for the dicta in this present case, in regards to the issue of suspicious circumstances, the learned judge in his opinion stated that the suspicious circumstances very much depends on the facts of the case. As in the present case, the suspicious circumstances or the sudden appointment of the defendant to be the sole beneficiary of the deceased will is a bit surprised, as they have been estranged for almost 20 years. But in fact, the defendant is still the deceased brother, and due to the betrayal and cheating on part of the plaintiff, it is possible for the deceased to overturn her decision in appointing a new beneficiary of her will. Not only that, by analysing the evidence adduced by the parties, especially by the deceased medical reasons or medical report, given no doubt in the non-giving signing of the second will instead of only thumbprinted as another mode of attestation.
As for the plaintiff's argument, it is contended that the first will is the last and the valid will. Therefore, the plaintiff sought a declaration to declare that the second will is considered null and void because there is an element of undue influence, fraud, and the plaintiff claimed that the deceased during the execution of the second will is said to be lacked of testamentary capacity. Other than that, during the execution of the second will, it is stated that there are suspicious circumstances that there is an influence made by the defendant in the execution of the second will by the deceased. To add, the plaintiff has declared that she has taken out a sum of money amounted to 7,298 ringgit and 40 cents from the personal account of the deceased in the Pacific Bank into the joint account owned by the plaintiff and the deceased, and a sum of 5,000 has been used to pay for the hospital bill of the deceased. Other than that, the plaintiffs argue that the second will dated 16 April 1999 is not actually made on date. Impliedly, the plaintiffs contended that the second will is to be considered null and void due to circumstances that has been stated before this.
The defendant in this case claiming for a declaration that the first will dated on 29 March 1989 was null and void, and thus the second will dated on 16 April 1999 was a valid will. One of the evidence, known as a diary of the event from the deceased admission to hospital until her death, which had been kept by one of the defendant's witness, who was his maternal cousin. According to the diary, the deceased had been complained about Amy, who is the first plaintiff in this case, where she had been cheated, taking things from her, and withdrawing the money from their joint account, and thus the deceased seek help from the defendant. Upon her discharge on 15 April 1999, the defendant and his maternal cousin accompanied the deceased to the public bank in Pulau Tikos to open her safe deposit box, which was a joint account with the first plaintiff, Amy. They spent quite some time at the bank to wait for Amy, but she never showed. Consequently, the deceased was angry and upset with the conduct of Amy, and this had been witnessed by the bank manager. The bank manager testified that the deceased was weak and frail. However, she knew what she was doing. Because of Amy's attitude, on the next day, Mr. Anamalai and his clerk came over to the deceased's house, where the second will and power of attorney was prepared and thumbprinted by the deceased. Consequently, the defendant had become the sole beneficiary of the will, and this had been witnessed by Mr. Anamalai's clerk and the defendant's maternal cousin. The defendant emphasized that even the deceased was not able to write but thumbprinted the will, she managed to speak normally, coherently, and alert with all the questions by Mr. Anamalai, although she was physically weak.
For this case is the validity of the second will is challenged by the plaintiff as it is alleged to be tainted by undue influence and perpetrated by fraud, thus regarded the will as null and void. The judge highlighted that it is a tried law that the pro-founder of the will or the executor of the will has the onus within the balance of probabilities to prove that the testator has the testamentary capacity to make the will. However, if the validity of the will is challenged from extraneous elements, namely undue influence, fraud, forgery, then the onus is upon who claim as so, as in the present is the plaintiff. This is why the mental condition of the testator when drafting the will and executing the will is one of the crucial components in determining whether the will was made when the testator had the testamentary capacity to do so or otherwise. Further elaborated in defendant's argument that when the second will was made, though the condition of the deceased from the previous days is described as confused, on and off, weak, and sometimes cannot form a good judgment on its own, however, that means nothing if on the day the will drafted or executed, the mental condition of a testator is stable enough and can form their own opinion. We have nothing but to agree that there is a lot of evidence that indicates on the day of the testator make a will and thumbprinted it, it was done according to her pure desire. Bare allegations from the plaintiff that the defendant an estranged of a biological brother, has put some sort of words to the extent that she created a new will favored the defendant has nothing concrete to authenticate it with. To put some more, the defendant's justification on why she took out the money from the joint account that she had with a deceased is immaterial and insufficient to shift the onus that she had appointed to her. Thus, the will is considered as a valid will.